Good afternoon, and thank you for joining me today. Today we are talking about New Jersey's second injury fund, probably one of the more interesting or complicated topics in New Jersey workers' compensation law. And my goal today is to both explain the importance of New Jersey's second injury fund, but also to give you some valuable strategies and tactics that you can use so that you're making sure you're getting the benefit of contribution from New Jersey's second injury fund, which should serve to reduce your exposure in your New Jersey workers' compensation cases. So thanks for joining me today. My name is Greg Lois. I'm the managing partner of LOIS Law Firm, and this is our regular New Jersey webinar series. Today, we're going to talk specifically about the second injury fund, and I'm going to walk you through the mechanics of how the second injury fund works, and then I'm going to start talking strategies and tactics with as many concrete examples as I can provide to you. So I'm hoping this is useful. All right, let's dive in. Please recall this is an instructional webinar only. This is not legal advice as to any particular matter. Of course, I'm going to talk about things that you're going to be able to apply to your cases, but it's not my intention to create an attorney-client relationship through either attending this webinar or listening to this podcast or video playback. This is a completely and totally live, see, I just messed up, webinar. And I do it like this on purpose because I do want people to ask us questions, and I want to leave plenty of time to answer your questions. The best way to do this is to type your question into me as the webinar is unfolding. I can see questions popping up. I can see that there's some pending. And then at the end, I will answer as many questions as I possibly can. So if I talk about something that you're unsure of, please ask that question. Even if you feel like, hey, Greg, this is a kind of a basic one, I feel embarrassed asking this question, go ahead and ask it. I'm sure there's someone else who's listening or maybe watching this on video playback who would have wished they could have asked that same question. So please do it. I'll never say your name, I'll just say your first name, so you know I'm answering your question. I will then read the question to the entire audience, and then I will do my best to answer it on the spot. So those of you who are attorneys, and I see there are some attorneys who have popped in here today, try to stump me, all right? I like to learn things too, so I'm looking forward to your questions. All right, our topic today is going to be how we get the best contribution from the second injury fund, obviously to reduce our exposure in workers' compensation cases. To get there, I'm going to very quickly go through the 4 different types of permanent total disability that are available under the New Jersey workers' compensation law. Now, I'm going to go through that very fast, probably 2 or 3 minutes. It's just going to be a refresher. And if you're saying, wow, that sounds deep, I really want to get into that, go back and listen to our webinar from September 2024, which I spent the entire hour on just the 4 different types of permanent total disability and how they are compensated, because they're compensated sometimes in different ways. So if you want in-depth on that, go back to the September one. If you're wondering, hey, where can I find those webinars? You can always find them on my firm's website, so you can go check that out. And then I'm going to talk quickly about odd lot claims, because that's another type of pre-existing disability, giving us credit for a total finding of disability. And then I'm going to dive into second injury fund. And I want to spend most of my time talking about the second injury fund, how it impacts your cases, and how you can get the best out of it. So without further ado, let's dive in. What is permanent total disability? Well, there are 4 different types of permanent disability, total disability, contemplated by the New Jersey workers' compensation law. I'm going to quickly look at each one of them. The first one is what we call statutory total disability. And the reason we call it that is because the statute simply says if you lose both hands or both arms or both feet or both legs or both eyes or any of those body parts together, meaning one arm, one leg, one eye, one hand, etc., you are deemed a total and permanent disability, okay? And we call that statutory total. It's essentially intended to compensate someone for a catastrophic loss to extremities. And there's a very specific type of award that the petitioner would be entitled to. They get an award of what's called statutory total disability, which is 450 weeks of benefits. This year, the current maximum is $1,159 a week, so that award is worth approximately $600,000. In addition to that, the petitioner would also be entitled to medical treatment for life for the injury conditions. Now, what's interesting about statutory total and really what separates it or distinguishes it from the other types of disability is that the petitioner can absolutely go back to work during that first 450-week period of disability, okay, that first 8.5 to 9-year period of payments with no reduction in their award, okay? So that's a huge benefit. They lose an arm and a leg, but they want to go back to work. They're motivated. Well, they still get that money award. It still gets paid out over that first 450-week period. So that's statutory total disability. Now, there's a second type of total disability, and this is where the petitioner does not have injuries that arise to what we'd call statutory total, meaning they didn't lose an arm or a leg, they didn't lose 2 arms, 2 eyes, 2 ears, any of those things, but because of the nature of their injuries, it wasn't an amputation, it wasn't a total loss of use, but it was very significant and it impaired their work ability, they can be found to be totally disabled, okay? And that's under Section 36 of the statute. And the petitioner has very specific burdens to prove. They will typically go out and get expert reports, and they will argue that their disability is totally disabled. They will also demonstrate that they could not work even if they wanted to. Just so you know, the standard in New Jersey is never same occupation disablement. It's any occupation disablement. So essentially, they can show that they're not able to do any job because of their medical impairment or their physical injuries. And for that reason, and by the way, it could be psychiatric as well. And for that reason, they are totally and permanently disabled. That's an award. Now, that award is for 450 weeks and then continues for the claimant's natural life. The next type of total disability in New Jersey is what's called odd lot total disability. I'm going to talk about this a little bit further, but odd lot disability is where the claimant says, yes, I did have a significant impairment as a result of my workplace accident, but I also had other factors that caused me to be totally disabled. Essentially, the petitioner in this case shows that their physical impairments or their neuropsychiatric impairment is at least 75% of total disability. And then they can say, well, and I had these other factors, which I'll talk about in a second, and those other factors cause me to be permanently and totally disabled. And the last type of total disability is called second injury fund total disability. And this is where the claimant has an injury at work, which by itself is not totally disabling, but they have pre-existing conditions, which when you combine them together, these medical pre-existing conditions, render them totally unemployable. And what's special about second injury fund total disability is that there is a special fund called the second injury fund, which will come in and compensate the petitioner for that pre-existing disability. And what that means to us as the employer respondent is that someone else is going to come in and pay a large portion of this award. And I'm going to show you just how impactful that really is in your real life cases. It is a significant, major reduction in your overall exposure. So we're going to talk about that at length. So before I jump into odd lot, let's just remember there's these 4 types: statutory total disability, legal total disability, and then 2 types of disability where we need to look a little bit further into the petitioner before the accident. The first one is that odd lot case. Those odd lot cases where the claimant says, look, I have a non-medical condition that prevents my return to work. What is a non-medical condition? It's something like, I don't speak English, I'm illiterate, I'm enumerate, I don't have any transferable skills, I have a learning disability or an intelligence impairment. And so that we could come up with examples where the petitioner receives a very significant impairment. Remember, the medical impairment has to be 75%. Plus, when you add in these additional factors like lack of English language skills, they are deemed to be permanently and totally disabled. Now, case law will tell you that odd lot cases, well, they're pretty rare, first of all. But what we're looking at is someone who has a significant impairment. Now, in the case that I'm citing here, Padilla versus Concord, even though he was able to work, his work skills were very limited. He did essentially manual labor jobs. And when he had that very significant medical impairment, no one was going to hire him again. So odd lot cases, again, very rare, but they do exist. Let's talk to the one where it actually reduces our exposure, and that's when the second injury fund contributes to our case. And this is an important opportunity for us. Again, I'm going to keep using the word opportunity because when we can get contribution from the second injury fund, It reduces our exposure and sometimes very significantly. And it also should influence our tactics or our strategies in our cases. Obviously, our strategy in every case is the same. Let's bring it to close as fast as we can. Let's reduce the exposure amount as much as we can. And where we can't, let's move this case to conclusion as efficiently as possible. Well, when the second injury fund's involved, counsel should really be helping you make sure that you're minimizing your exposure. So let's quickly talk about why it exists, how it works, how does it reduce our exposure, and then I'm going to leave some time at the end for your questions and answers on this very interesting topic. So why does it exist? Well, the second injury fund was created right at the end of World War I to encourage employers to hire employees who had pre-existing disabilities. So think about the end of World War I. We have, unfortunately, our veterans coming back to the workplace, and unfortunately, they have significant injuries, some of them, amputations, etc. Well, I already defined for you that statutory total disability is the loss of both hands, both arms, both feet, both legs, both eyes, or any two thereof. So do you want to hire a disabled veteran who's coming back to work for you if they already, for example, have lost their leg in the war? Well, when you contemplate the exposure under statutory total, you'd say, no, I don't want to hire this person because if they lose the other leg or any other body part or an eye or an ear, well, all of a sudden you've got a total disability case. And obviously when you hired them, they had a good work ability, right? So the idea is to protect the employer and to encourage them to hire people who might have pre-existing disabilities. So the second injury fund was created to pay for situations where the petitioner is now totally disabled. Again, we're talking about completely and totally disabled, but they had a measurable disability before the employment, and the combination of those two disabilities now renders the claimant totally disabled. Now, the way this works is the petitioner or the respondent must claim or concede total disability, and I'll talk in a little bit about the tactics that you may want to deploy when you're considering doing that. The next thing is we must show a disability before the last employment accident. In other words, we have to argue that before the last employment accident, which was probably pretty significant, they had a pre-existing disability that impaired either their activities of daily living or impaired their working ability. And there's lots of ways we can show that, obviously through medical records, but even through things like the employment records, which would maybe demonstrate, hey, this person was using a helper or had an assistant, or they were put on a light duty assignment because they couldn't do a full duty assignment. Those types of things are going to be all the types of proofs that we're going to want to look to. And the last thing is, so in order for the second injury fund to come in and contribute to your case, the petitioner must now be totally disabled, meaning not working due to injuries. They cannot retire voluntarily and then claim to be totally disabled. That's obviously a defense to the person being disabled in this jurisdiction. So how does it work? How does this work mechanically? Well, the respondent still pays for the portion of the new disability or the disability that's related to the workplace accident. But the second injury fund pays for the pre-existing disability and pays for the remainder of the claimant's life. And this can be a significant reduction in our exposure. Let me give you some examples and talk through a little bit about how this works in dollars to donuts sense so you can get a sense of how impactful this will actually be in your cases. So here's our happy worker, our future petitioner comes to work for us. But when they come to work for us, they have a previously loss of their foot or leg, okay? That's the pre-existing condition, all right? So imagine the veteran who returns from war and has this pre-existing disability. And again, I'm choosing a simple one, an obvious one, loss of a foot. It's either they're there or not there. So this is an amputation case that we're talking about. But I don't want you to limit your imagination to it has to be the loss of a hand, finger, foot, toe, eye, ear. It could be anything. It could be they had a pre-existing depression. It could be diabetes. It doesn't have to be work-related at all. It doesn't have to be something that we would normally compensate in a workers' compensation sense. So again, anything that would impact their activities of daily living or their ability to earn an employment or be successful or flourishing as an employee, any of that would be considered. Again, I'm just choosing a simple exemplar here, loss of a foot, okay? So now they come to work for us and they're working at the time of their accident with us, and unfortunately, they've now lost the other foot. It got pulled into a machine and chopped off. So looking at this person and going back to our definition of total disability, well, they meet the definition of total disability under Section 12. They had a previous loss of a foot, now they've lost the other foot. Well, loss of both hands, both arms, both feet, or both legs is total disability. So if this was our employee and there's no such thing as the second injury fund, we would be exposed for that disability. So let's talk about what that would be, again, presuming there's no second injury fund. Well, first, they would be entitled to the 450-week award that is the maximum award for a total disability. So that's 450 weeks. Then they would receive benefits for the remainder of their life. So whatever their life expectancy is. They would also be entitled to medical treatment, which again could be stump care, could be prosthetic replacement, could be any complications arising from the amputation or the use of the prosthetic, again, for the rest of their life. And that's how you would calculate your exposure. You would say that initial 450-week period, the number of weeks in that person's life expectancy, a cost projection for the medicals, and that's how you would come up with the total exposure. So far, I hope you're with me. This is not complicated. This is basically how you would price a total disability case. Let's put this in dollars and cents. Remember, they're entitled to that 450-week period, so that's 450 weeks. Then let's presume, and if you can go down to the bottom, you can see I'm giving them an average weekly wage of $600 a week, which is a pretty low average weekly wage, and saying that they're 61 years old. Well, they would have a 17.3-year life expectancy, so they would be entitled to another 449.6 weeks. Then we would have a cost projection for whatever the medicals are. And I could tell you that just using those figures in front of us, that exposure would be about $539,400 plus medical. And again, that's using current rates, okay? So that's a pretty clear example of what the exposure would be if you had an employee with a total disability. Again, the loss of 2 limbs, 1 pre-existing and 1 lost from the work. But I already told you the second injury fund is intended to come in and step in and take responsibility for the amount of the pre-existing condition. So now let's do the same exact calculation, but presume that the second injury fund is going to give us some contribution for the prior loss of the foot or leg, okay? And just to keep this entertaining, I'm going to imagine they only assume, or they only contribute 1% disability, okay? Now remember, the second injury fund contributes when the petitioner is now totally disabled. Well, guess what? Statutorily, they're totally disabled, right? Because they've lost both legs. And they had a measurable disability before the employment. Well, we're going to argue, hey, this person had already lost their other foot, so they had a measurable disability. And the second injury fund will pay when the combination of the prior plus the new accident renders the claimant totally disabled, which again, we know he is totally disabled as per the statute. So what is the prior loss of the foot? Well, the foot is compensated in terms of 230 weeks. Let's just pretend that the second injury fund is only going to contribute 1%. Again, that's extremely low. I think a good attorney would argue for a much higher degree of participation or contribution by the second injury fund, but let's just pretend they are only going to contribute 1%. So let's take a look at our example now. Remember, the rate is $600, so I'm looking at a chart now. The number of weeks, if there is no fund contribution, the initial award period would be 450 weeks. The petitioner is 60 years old and they have a 17.3-year life expectancy, so we would pay an additional 449.6 weeks for a total money exposure, remember this does not count medical, of $539,400. Now let's imagine the second injury fund contributes just 1%. Well, 1% of 450 is 4.5 weeks. And that's why I would tell you your new initial exposure period amount is 446.5 weeks. And what's magical about the second injury fund is that after the initial disability period, it will then take over all payments until the claimant expires from their natural causes. And again, you've now just avoided 17.3 years of payments. This reduces your exposure to $267,600. roughly half. And again, that's with a very small contribution from the second injury fund, just 1%. Again, I will tell you that if the claimant has a pre-existing loss of one leg and now loses another one at work, your attorney should be arguing strenuously for much more. I think they should be arguing for something like 20, 30, 40% contribution by the second injury fund, which would push that figure down even further. So I could just tell you, just in math, using the numbers, which are just as clear cut as I can possibly make them, you can see this is a major reduction in your exposure where the claimant has a pre-existing disability. All right, this sounds great, Greg. Let's do this. All right, let's talk through how we get this contribution from the second injury fund. So how we get their contribution? Well, first, there needs to be a filing of a verified petition, which I'll talk about in a second. There needs to be some documentation demonstrating the pre-existing disability. There also needs to be a medical report finding them totally disabled. In my experience, the Deputy Attorney General who represents the second injury fund in New Jersey, they're not going to pay attention to just attorneys claiming that someone's totally disabled. They're going to say, I need to see medicals, so documentation of that, and I need to see a medical expert report that opines as to their total disability as well. In addition, we should have information about the petitioner's Social Security disability awards, any other pensions they have, because if they are a state employee and they get a state disability pension, that could also reduce their workers' compensation award. It's a relatively an edge case under Rosales, but it's still something I'll talk about in a second. Now, what are the things the fund, the second injury fund, never pays? Well, they never pay for the cost of any medical treatment. The cost of medical treatment going for the rest of the claimant's life that's related to the compensable condition, right, the last accident, that's always going to be on the respondent. So you're never able to shift that medical burden to the second injury fund. They also never pay costs of suit or attorney's fees. In other words, they do not contribute towards attorney's fees. Any attorney's fee that is awarded to the petitioner in a total disability case with second injury fund involvement would come from the respondent and the petitioner. It would never come from the second injury fund. The fund never pays anything towards a Section 20 lump sum dismissal. They simply lack authority to do that, and they will never make an offer to resolve a case under Section 20. They do not pay for dependency benefits. The argument there would be that the last injury killed them, and even if there was contribution towards the death, the fund is excused from paying dependency benefits. The fund never pays anything in a less than total disability case, which you could also call a partial disability case. In that instance, if you can demonstrate a pre-existing condition, you should use the Abdullah case law, which says that the respondent gets a dollar for dollar credit for any pre-existing disability. They never pay when the last accident is totally disabling by itself. So if the last accident is the real cause of the total disability and the pre-existing conditions are very minor or not disabling in and of themselves, the second injury fund will not contribute. They also will not pay when the injury that occurred at work slowly progresses into total disability over a period of years. They will argue that it has to be a clear-cut last accident. And so what you'll discover as you try to get contribution from the second injury fund in your cases is the second injury fund has some common objections to being dragged into our cases. And some of these objections will be, hey, Greg, nice try. Thanks for trying to bring me into this case. But really, the petitioner was totally disabled by the last accident alone, and the pre-existing disability had really no impact on their overall disability. All right, that's a common objection that you're going to hear from the second injury fund, and you need to be prepared to meet that with facts. The second injury fund is not out there doing discovery. They are not calling witnesses. They're not talking to the employer. So this is where we have to use our advantage and our discovery opportunities to make sure that we are creating an accurate record which demonstrates the medical impairment that the petitioner had before the last accident and also the medical treatment they had, as well as any impact on their activities of daily living. This is also going to be a great opportunity for us to use one of our advantages, which is communicating with the actual employer to say, hey, what did this person do? Was it a sheltered employment? Were there accommodations made? Did they have help? Were they moving slower than everyone else because of their pre-existing disability? We're going to want to get that information from them. The second objection that I hear so often from the second injury fund is, Greg, this person is not totally disabled. Why are you trying to drag me into your case? I have nothing to do with this case. This claimant is not totally disabled, Greg. We should not be here. And again, you're going to need fact documentation and probably a strong expert report to rely on that would argue that the claimant is totally disabled. And the last defense that I hear from the second injury fund is the Walmart greeter defense, which, by the way, is only getting stronger as the employment landscape has become looking for entry-level positions all the time. The Walmart greeter defense is, Greg, this person's not totally disabled. Yes, I recognize he's lost both his legs and he has an eye patch and he's got a hook for a hand, but couldn't he still work at Walmart as a Walmart greeter? Couldn't he still do that, Greg? And so they'll make this argument that the person is not unemployable, which is ridiculous. I mean, we would make the argument, hey, statutorily they meet the requirements of the statute for total disability. It's disingenuous to make these arguments that somewhere, someday, someone, maybe, would hire them for some ridiculous entry-level or sedentary position. So those are the common objections, and your attorney and the petitioner's counsel need to be aligned in overcoming those objections, which are typically going to be raised by the Deputy Attorney General, who represents the second injury fund. All right, let's talk strategy now. Let's talk about some practice pointers, and let's talk about how we utilize this in our cases. And again, I've gone through some examples which are pretty clear-cut and also pretty obvious, but I want to talk about a couple edge cases and some nuance about this. And I want to get you thinking about how you can deploy this in your cases successfully. I can tell you right now that in order to be successful in getting contribution from the second injury fund, you need to understand how it works and what your goals are. We want to be realistic about whether the second injury fund is going to contribute. Otherwise, this is an adventure. This is a litigation adventure you're going to go on for not much result. And again, your goal here is to get someone else to throw money into your case, which is reducing your exposure as the employer. And from the petitioner's perspective, their goal is to get the second injury fund to contribute to the case because it makes the finding of totality more palatable or acceptable or amenable to the employer or respondent. So those are the broad strategies that we're trying to deploy. So let's talk about the first issue, okay? Who files for second injury fund relief? Well, the rules say that a claim petition must already be filed and then a verified petition must be filed. And this, by the way, is a little bit of a departure over prior practice. Prior practice used to be a motion to join the second injury fund. Now it's a verified petition. And the verified petition needs to be filed within 2 years of the date of last payment of compensation by the employer or carrier. Now, if you're ever caught out by this, by the way, as an employer or carrier and say, well, we haven't paid in 3 years, but we now realize we should get second injury fund contribution. Well, there's nothing that stops you from making a payment of temporary disability or partial disability or voluntary tender and then restarting the clock. So just be mindful that the Deputy Attorney General will raise this as a defense if you have not been paying. Now, I want you to be thoughtful, though. The petitioner might not want to file a verified petition. They might say, I don't want to go through the rigmarole. I think I'm totally disabled, and I think it's all due to you, employer, all due to you, respondent. I don't think that my pre-existing conditions really were disabling. I think that's a red herring. I don't want to go through the time, effort, blood, treasure, adventure with the Deputy Attorney General. I think I can get total disability against you. Okay. You're not out of luck. You could still, as the respondent, say, you know what, I'm going to file the verified petition on your behalf, right? Because both parties, respondent and petitioner, have the opportunity to file a verified petition. We don't need anybody's permission to file one. It's a little bit dangerous, though, and this is the caution, and this is where you need to be thoughtful. If you're filing a verified petition, you are stipulating or conceding, I would argue, that the petitioner is totally disabled. In other words, you are saying, I believe this person is totally and permanently disabled, and I believe that there is some contribution that we're entitled to because of their pre-existing conditions. Be careful. If you're not successful in getting second injury fund contribution, I think savvy counsel representing the petitioner will just turn around and say, well, Your Honor, haven't they just stipulated to total disability? Thank you very much, pay me my money. Okay, so just be careful and be thoughtful about whether or not that's a stipulation that you're willing or ready to make. So think about that as a strategic point. If the petitioner refuses to file the verified petition, and they might have valid reasons to do that, the respondent can file it, but I'm going to tell you, beware. Next thing, acquiring proofs to support the verified petition. I already told you that we're going to need to document the pre-existing condition. We're going to need to assemble strong proofs. Now, this is where the two strategic points I have that I want to talk about. The first is, if you go back to our presentation back in January, and I know everyone who's listening here today came to that one, we talked about discovery methods, discovery tools, discovery processes. And one of the discovery processes I talked about was that the New Jersey law allows the respondent to serve what's called a demand for statement of pre-existing conditions on the petitioner. And it's meant to protect you in cases just like this, these cases where there might be a total disability against you, the employer, but there might be an opportunity for you to get contribution from the second injury fund. By serving the statement of pre-existing conditions on opposing counsel, they must respond to it and say, well, here's all my pre-existing conditions which impact my ability to work. We serve this in all cases as part of our regular discovery. And as the case develops and we discover, hey, maybe this person is totally disabled, we're going to want to push hard for opposing counsel to force their client to execute that statement of pre-existing conditions. It's going to give us a starting point to go and start doing discovery, to use HIPAAs or subpoenas to obtain information regarding any pre-existing condition that we can identify, which might be basis for second injury fund contribution in our case. So that's an important piece of discovery to do early. I can also tell you that when clients transfer files to us from other defense attorneys, I rarely see that statement of pre-existing condition go out. And if I think it's a bad case or a total case, I'm going to want to immediately serve that piece of discovery. So just be wary about that. Second point, strategic point. Sometimes opposing counsel doesn't want to make a claim for second injury fund contribution because they understand this is going to slow down their case and it's going to cost them money. It's going to slow down their case because now you're bringing in a third party, and the third party is the state of New Jersey. Does anyone think the state of New Jersey bureaucracy moves at lightning speed? It does not at all. So you are adding in a slow party that's going to come into the case and ask a lot of questions. But the second thing is now they're going to have to demonstrate this pre-existing condition, which from their perspective means getting HIPAA releases from their own client, issuing them to all these providers, assembling all these medical records, developing a longitudinal record or medical index which demonstrates that there was a pre-existing condition. It's work. And now if you're a petitioner's counsel, do you want to do work? No. So sometimes we'll tell them, look, we're going to do all the discovery for you. We're going to go out and we're going to do the subpoenas and the medical index and the canvases and get the records together. You don't have to do it. We're going to aid that. And so the thing that I want you to think about is, hey, in a case where you might get second injury fund contribution, you and petitioner's counsel all of a sudden might become aligned. You're not enemies. You're not opposing at this point. You're both saying, hey, this person's probably totally disabled, and now you're trying to get a third party to come in and pay for your case. So all of a sudden, you're not oppositional with opposing counsel. You're working together. And if I can help them assemble their case more quickly, well, that's more efficient for my client as well. So again, think about that tactically or strategically. Maybe you're engaging with opposing counsel to work together to assemble the relevant proofs. Also, and this is another pretty arcane thing, but New Jersey is a reverse offset state. What does that mean? It means that when the petitioner has a Social Security disability benefit or award, we can get an offset or reduction in the amount of our workers' compensation award because of that. The reduction is the amount over 80%, the amount of the workers' compensation benefit and Social Security benefit that exceeds 80% of the petitioner's pre-accident average current earnings. Now, what that means is in your most serious cases, most significant cases where you're looking at a potential total disability, the petitioner has probably already filed for Social Security disability or is in the process of getting a Social Security disability award. As we all know, Social Security disability awards are much easier to obtain than a finding of total disability in New Jersey Workers' Compensation Court. The burden of proof is a lot lower in a Social Security proceeding. And so it's very likely, in fact, most of the cases that we have that go towards total disability or total disability with second injury fund contribution, the petitioner is already receiving a Social Security disability award. And that benefits us. When they're receiving a Social Security disability benefit award, that can allow us to use what's called the reverse offset to reduce the amount of money we're paying. Now, the strategic point here, the thing to be mindful of, most total cases will also involve a Social Security disability award, and this can significantly reduce our exposure. So let's talk about how this actually works. The workers' comp benefit plus the Social Security benefit cannot exceed 80% of their ACE, average current earnings, as calculated by the federal government. The workers' compensation benefit gets reduced, which means it reduces our indemnity exposure. There is a complicated formula for how the 80% ACE is calculated. And I put a reference up on the screen to that. But in most cases, it will be as simple as requesting that information from the federal government. That's typically done by petitioner's counsel. So let's look at the example of how this actually works. In our case with the claimant, who is, again, we're going to use the rate of 60%, rate of $600. Total with no fund, our exposure is $539,400. With second injury fund contribution, that gets reduced significantly, and this is not new information. This is what I've talked about earlier, to about half. But what if we also get a Social Security offset? Remember that they're 60 years old, and so we're going to get that offset until they're going to hit the age of regular retirement, which is age 65. Now, for the purpose of this example, just imagine that the reduction would be worth $200 a week to us. Well, that's a $50,000 offset, which would further reduce our indemnity exposure to $217,600. So this could be a second avenue for us to reduce our exposure in a total disability case. Again, this is because New Jersey is what's called a reverse offset state. Now, interestingly, if you're one of my clients in New York does not have a reverse offset, and Social Security gets the benefit of an offset against a New York total disability award. But in New Jersey, it is more favorable to employers. This is probably the one instance where it's more favorable to employers, and we get the benefit of this offset. Now, the next thing I want us to think about is comparing an award of total disability to non-total disability. So I'm just going to give you an example. Let's imagine you have a maximum wage earner in 2025. And to be a maximum wage earner in 2025, it means you have to make about $80,000 a year or slightly more. It's where your average weekly wage exceeds $1,655.71 a week. Now, for that maximum wage earner in 2025, a finding of 75% partial disability, again, remember, they're not totally disabled, 75% partial disability equates to 450 weeks of compensation, or $521,550. That award would also be subject to reopener, remember, because it's a partial award, so they could come back and say they got worse. And of course, their medical could be remains open as well. Now let's take the exact same petitioner, and now let's find that they're totally disabled. If they're totally disabled and I can get just 1% contribution from the second injury fund, my indemnity exposure now drops to $517,000. $517,493 and change. Okay, so it's slightly cheaper. But the benefit is there's no possibility for reopener. And if the claimant's younger than age 65, I might also get a reverse offset, so I might even reduce that further. Okay, so what you're looking at here is an example where it might actually be cheaper to total someone and get a very tiny contribution from the second injury fund than it would be to pay a high partial disability award. In cases where the average weekly wage is less than sufficient for max, in other words, in cases where the average weekly wage of the petitioner is less than $1,655 a week, the difference between a high partial total award and award with second injury fund contribution will even be more favorable to the respondent. And the big takeaway from that thought is, when I have a case involving catastrophic loss, significant injury, we know it's going to have a high degree of permanent residual disability. As your defense counsel or as your risk professional or as the adjuster handling that case, you should be thinking to yourself, wait a second, would it actually be more efficient, more cost effective, cheaper, and more straightforward to total this person with a very small contribution from the second injury fund? It might be more efficient, and I can tell you it'll be impossible for them to reopen that case. And so that might be another benefit, that you would have a true closure. So those are things to think about, and those are some of the big questions that I want you to start thinking about in your cases. All right, before we turn to questions, and if you haven't typed your question in yet, please do it now. I'd love to answer questions. Let's look at some takeaways for today. Contribution by the second injury fund, even if for just a small amount, decreases your exposure incredibly significantly. And I think I showed you in math how just a 1% contribution by the second injury fund essentially drops your exposure in half. It's very important for you to think about that. The second thing is strategically consider who files for the second injury fund contribution. Just because the other side is not pursuing it doesn't mean you can't. And also you should be thinking about, wait a second, is there a potential, if this person's totally disabled, for me to get a reverse offset, which again, might be more efficient than paying a partial disability award? Last thing I want you to think about and take away and try to apply. It may sometimes be preferable and more efficient to have the petitioner be totally disabled to get some small contribution from the secondary fund than it is to litigate a case to a less than total degree of disability. By litigating that case, you might actually be opening yourself up for the potential for a reopener, and you will be the potential for maybe in a higher award. Now, what I did not talk about today is the impact of public pensions on total disability awards. But I will just very briefly say that if the claimant is entitled to a public pension for accidental disability retirement, that could further reduce your exposure, because case law says that the workers' compensation benefit, Social Security disability benefit, and accidental retirement benefit cannot exceed the earnings while actually working, or 100% of ACE. And for that reason, you might even obtain a bigger reduction in your exposure. Didn't go into that here today because it's very small percentage of cases that fall into, and over the last 20 or 30 years, it's been a tiny percentage, but it is something just for you to think about. All right. Let's dive into some questions and answers. And this is the part I like the most. So I'm hoping there's some good questions in here for me. I'm going to open up the question pane. And I should also say this, you don't have to ask me questions about today's topic. It could be about any topic. This is really your opportunity to try to stump the managing partner and see what I know or do not know. Okay. Andrea asked the question, Greg, I have an employee who had a lumbar fusion in another state under workers' comp. No perm was awarded on that claim. We now have an exacerbation lumbar and likely heading to a revision surgery. Would this prior surgery trigger second injury fund eligibility? Yeah, absolutely. They had a pre-existing condition and in your case, and if they're totally disabled, that pre-existing condition would be the basis for second injury fund involvement. Now, I can also tell you, if your case does not go to totality, you would have a right to credit for pre-existing disability under the Abdullah case. So remember, you get a dollar for dollar credit in New Jersey at today's dollars for pre-existing injuries to the same body part. So either way, Andrea, it sounds like you're going to have either a great credit on a partial disability award or grounds for second injury fund contribution if that revision surgery doesn't go well. And as we all know, revision surgeries generally don't go well. So good luck to you, Andrea, on that case. Teresa, can you only get the reverse offset if second injury fund is joined? Great question, Teresa, and thank you for paying attention. No, you can get a reverse offset in any total disability case. But because we're talking about total disability cases today, and because I was thinking about how does this really impact exposure, I wanted to discuss that. But no, absolutely any case where you're 100% responsible, so there's no second injury fund contribution, you're 100% responsible for the total disability award, and the claimant is also receiving a Social Security disability benefit, yes, you can then claim the reverse offset as well. Okay, so a reverse offset applies in any total disability case, regardless of second injury fund contribution or involvement. All right, great questions. Love those questions. I love them because everyone's paying attention today. So that was great. All right, I hope everyone had a great experience today. It was a pleasure being with you. As you can tell, I'm excited and animated and passionate anytime I can talk about an opportunity for us to reduce exposure and save some money for the poor, embattled employers of New Jersey. Oh, here we go. Jack says, Greg, for a total case, do the heirs get the life expectancy portion if the petitioner dies, or was that just used to show exposure? Jack, great question. Okay, came in a little late, guys, but I'm gonna answer this one. In a total case, no, once the claimant dies, if they die of something unrelated to the workers' compensation award, then no, the exposure ends. So if the claimant has a lot of comorbidities, that would impact it. Again, my examples are attempting to be as simple and straightforward as possible, but it is accurate that if the claimant dies while they're receiving a total disability award, there is no benefit payable to their dependents, again, unless it's something related to the workers' compensation accident that ultimately causes their demise. So I hope that's a full answer for you. All right. Again, I was wrapping up, and that last question popped up, and I wanted to answer it. Have a great month, everybody. I'll see you next month for our next topic. Have a great rest of the day, great rest of your week, and enjoy May. Thanks, everybody. See you next time.